Hi, everyone. Welcome to the Brown Sense Live. We have today a lawyer by the name of Masala Ratshitanga. He is the founder of Ratshitanga Attorneys. I hope you can hear me live and direct. This is very exciting for me. He'll be coming onto the screen just now, but I want to, just touch on, one or two things. Or maybe one rather, and that being, the topic that he's going to tackle today. It's rather, dear to me, and especially because when the law came out, one of the biggest things and worries and concerns was, what does it mean for the SMME space? We are adding one more compliance or regulatory requirements. How is it practical, and what is the expectation in as far as they are concerned? And Masala will be coming onto the screen shortly, and he will be unpacking how SMMEs can in a practical way, day to day, and without adding much burden on what's already on your plate, and making this much easier. Please give us a minute or two before we add him to the screen. A bit of a technical glitch on the Facebook side, but we'll be online in 5, 4, 3, 2, 1. There you go. Good morning, sir.
Morning.
How are you?
I'm good. I'm good. How are you?
I'm good, thank you. Yeah, so I was just, firstly, thank you, Masala. If I may give our audience some context, Masala is the one that reached out to us and, basically offered, that there's a topic that he would like to do a webinar on, that he believes will benefit a lot of Brown Sense members. But I believe anyone that's in business, whether or not you're in Brown Sense, you're going to benefit from this. And it's something, as I said, Masala, before you came onto the screen, that when the act came out, one of my concerns was how does this, what does it mean for the
Yes.
SMME, right? Is it the addition of one more compliance or regulatory requirement that's going to make doing business that much hard in South Africa? Just a brief intro about Masala, before he takes over. Masala is the founding director or MD of Ratshanga Attorneys. We will add the details on the screen as the webinar continues. Ratshanga Attorneys is what I would call a full suite law firm. From commercial law requirements, labor law, data privacy, you won't bail me when I'm in jail, right? Or should I call you if I'm in
We
trouble with
also
that?
do provide we also do provide some criminal law defense
Criminal
services
law,
for
family law, and awesome.
applications. Yeah, but family law is not one of our services at the moment.
Okay, okay. No, that's great. As I said, we will add the details for our audience. But Mr. Rachitanga, this is about you, and I can't wait to hear what you have for us as
Yes, yes.
I get myself off the screen and hand over the reins to you.
Great, thank you. Thank you very much, and thank you for the great opportunity. First of all, yes, as mentioned previously, I reached out because I really wanted to have this conversation and do a session on POPI compliance because it is. Just give me a moment there. Sorry for that. Just had to sort out something very quickly. So, as previously mentioned, I reached out to Brown Sense because I wanted to have a great discussion on POPI compliance. Having had experience in different environments dealing with POPI, I was keen to get into a discussion on POPI compliance requirements and actually be able to cut through a lot of the confusing legalese aspects of compliance and be able to pinpoint practical pointers and tips that SMMEs can implement. Being an SMME ourselves, we had to consider that our priority as an SMME in the economic climate we're in is being able to focus on the work that generates revenue for our business. So we in our implementation of the various legal solutions we provide to our clients always prioritize practicality, and we felt that there might be a use and we can provide some benefit for SMMEs by being able to have this session on POPI compliance because in our understanding of POPI compliance and having to deal with POPI compliance requirements in the past couple of months, POPI is a very wide ranging and applying law. It applies to a lot of business operations because most businesses process personal information and most businesses fall under the definition of responsible parties in terms of POPI. I'm sure a lot of SMMEs who might be aware of have some steps that they've taken in their POPI compliance journey have also come across the very wide definition of personal information included in POPI and also the very wide definition of processing that is also included in POPI. So I do understand. I really went in there and I started with more of the discussion regarding the act itself. But to introduce myself, my name is Masala Ratshitanga, as touched on before briefly. So I am founder and managing director at Ratshanga Attorneys Incorporated. We're a full service law firm that's based in Centurion, and we provide a variety of services for entrepreneurs, individuals, and SMMEs, and some large businesses also in and around the Gauteng area. So we are able to provide services ranging from commercial law, be it your deal making, drafting your contracts, negotiating your contracts, or vetting your contracts. And then we can also assist with any compliance requirements you might have. This is either from a POPIA compliance perspective, a company law perspective, competition law perspective, and any other areas that you actually require assistance with compliance. And then we also provide general litigation services and also some criminal law defense services. So that is briefly the law firm. We will provide further information in terms of our professional and company profile, as well as further information relating to how you can get hold of us, how we can have a further session after this session, should you be interested in taking up our services to actually either get you on your compliance journey so that you are compliant with POPI, or to actually enhance the journey that you've already started on. So I think we can now get into the presentation. Thank you. Perfect. So we've prepared a very brief presentation, and the idea beyond the presentation is to be able to generate engagement. The idea behind the session is not so much a massive focus on the sections in the Act. We want to steer away from that, but rather be able to have a discussion on a more business to business level and on a more actual practical actions. And thank you, Bella. Bye for now. And actually be able to have a further discussion on sorry about that. That is my daughter Bella. She was just giving me a hug. And to continue on the presentation, so our analysis and the presentation and how we want to be able to deal with the session today is to be able to give practical pointers and practical tips that can be implemented on a business level and a practical level to be able to actually pinpoint what different things you are doing in your business currently, how you are processing personal information in your business currently, because there is a very high likelihood that you are processing personal information and you would be considered a person, a responsible party in terms of the act. So just briefly, the first slide is to give a snapshot of the current state of events in relation to POPI compliance. So point one there just talks about the commencement date. So the commencement date of the act was 1 July 2020, and the act provided for a grace period of 12 months for organizations to be compliant with the act. So point two there shows that the grace period for organizations to comply with the act expired on the 1st of July 2021. And then on the 3rd of July 2023, as pointed out in point three, the information regulator issued its first infringement notice. The infringement notice was issued to the Department of Justice and Constitutional Development, and the infringement notice was for an amount of 5 million rand. We have written about this and posted it on our LinkedIn page. Please also have a look at our LinkedIn page and follow us there just to get more tips and more information on compliance and other topics. So the infringement fine we are referring to here was in relation to a compliance notice that had been issued to the Department of Justice and Constitutional Development to actually comply with provisions of the Act. The compliance notice that had been issued previously requested the Department of Justice and Constitutional Development to implement certain actions within their operations. Those included renewing antivirus licenses and also renewing licenses for certain frameworks and applications that they used in their processes of processing personal information, and also to hold certain people accountable within the organization who failed to renew those licenses and who failed to safeguard the processing of personal information, wherein there was actually a loss of data. So the Department of Justice and Constitutional Development failed to comply with that compliance notice, and as a result was issued the infringement notice. They have various options that will assist, that will be available to them in regard to the infringement notice, and ultimately they could be in a position where they have to pay the full amount, or there has to be further discussions that need to be held with the information regulator in terms of arranging some type of installment settlement in relation to the infringement um, um, penalty that has been levied against the DOJ and CD. So as mentioned, the fine is an amount of 5 million rand, which is in itself a very massive amount. It's a substantial fine. So it actually, this moment in the implementation of the Act shows two things. The first thing, that the information regulator is ready to enforce the Act and that they will enforce it. And secondly, it also shows that the penalties that can be levied in terms of the Act could actually be quite substantial amounts. And also bearing in mind that the maximum amount could actually be up to 10 million rand. So when we then have the further discussion around compliance, we should be looking to making decisions that will avoid any kind of infringement on our side as organizations. And that is purely up to you what you decide and what your next step will be in your POPI compliance journey. Please move on to the next slide. So in our experience dealing with clients, when we start on the POPI compliance journey with a client, or we start helping a client on the POPI compliance journey that they've already started, we will usually come across a roadmap that looks like this. One really can't call this a roadmap because there are so many divergent paths. You can see that there are a lot of paths that some of which are not really leading in any direction, because a lot of clients that we've interacted with and we have had discussions with regarding their compliance efforts either don't understand how the Act applies to them. In some instances, some will insist that the Act doesn't apply to them. And you would actually have to have a further conversation to show that indeed the Act applies to you. So you will find the compliance journey is either non-existent. If it has started, you will find that it has no direction. And then in some instances, you will find that it has started and then stopped because the client is not aware of what their responsibilities are. In some instances, you will find that there is an effort to comply with the act, but the focus is too heavily on the conditions stipulated in the act, the conditions for the lawful processing of information. Some of the conditions become addressed, some are not addressed, and in some instances you will find that there is a lot of confusion about who is responsible for what in the organization, um, what appointments need to be made, what stakeholder engagements need to be held, what kind of awareness efforts need to be made. So compliance will always be different based on the type of organization and the size of the organization. So this session and the service offering we provide is very heavily focused on entrepreneurs and SMMEs so that we can actually slice through a lot of the legislative and legalese aspects of compliance and get to the practical steps of what is it that needs to be implemented, what can actually start getting done as soon as we have had a conversation and a consultation with the prospective clients. So you'll see on this kind of roadmap, there are a lot of questions that need to be answered, and those could lead to confusion in some instances. So as I mentioned, a lot of prospective clients will ask, does the act apply to me? Does it apply to my organization? Am I a responsible party? And what does that mean? There are instances where you will find the prospective client understands that the act applies to them. But then the next step is an understanding of the act itself. How well do they understand the act? And then how well do they understand its application? And then further to that, the questions that may need to be answered are what kind of personal information does the organization process, and how is that personal information processed? Then further questions that would be asked, who is then responsible for POPI compliance in the organization? Because in some instances, you would have various people who are responsible for different things within the organization. You could find in some organizations compliance requirements sit with a compliance function within the business, while some compliance requirements sit with a legal function within the business. Then there are also questions around who is the information officer. Are there any further appointments that need to be made? Do we need to appoint deputy information officers? And then what are the next steps? And then further to that, there are questions around impact and actions. What resources will the organization require? What are the next steps? And also what will happen if there is a lack of compliance? Let's please move on to the next slide. So in our view and our service offering, we want to be able to help the client to have a POPI compliance roadmap that looks more like this, where we can actually be able to identify from an initial stage, from step one, all the way to what we've highlighted there as POPI compliance ongoing support. We want to be able to provide a service to the prospective client and be able to have discussions on determining how the act applies to the client's business operations. So this roadmap will cover a lot of the practical tips, which is the main focus of this session. So in terms of application, a lot of clients will come to us and ask, okay, how does the act apply in the first instance? And to answer the question, there is a very high likelihood that the act will apply to an organization in South Africa. So the application of the act, just to cover that briefly, is that the act will apply to a, a responsible party, a party that is processing personal information that is domiciled in South Africa. Domiciled basically means that it will have its physical address or operational address in South Africa, and that is processing personal information in South Africa. And there are some certain exceptions where the act won't apply. For example, where the processing of personal information is being done for household purposes. But then if we're in a business setting, that exception will not apply right away, because in a business setting, personal information will be processed for business reasons. So the answer to that initial question, does the act apply to my organization? In most instances, is that it is yes, the act applies to your organization. And then the second question becomes, what now? In our analysis, we'll find that a lot of prospective clients are responsible parties or operators. So a responsible party will be the one processing personal information for their own use or for their own operations. And then an operator would be an organization that will then be processing personal information on the instruction of a responsible party. In other words, they are processing the personal information as part of their own business operations, but for the purpose of providing a service to a responsible party. So in that instance, you can see very quickly how the act has a very wide range of application, in that it will apply to a lot of organization and a lot of businesses that conduct business in South Africa, because a lot of businesses are processing personal information. And as I've mentioned previously, the definition of processing in the Act is a very wide ranging definition. It includes collecting the information, it includes documenting the information, it even includes deleting or destroying the information, it includes archiving, it includes a lot of things. And then the definition of personal information itself is also a very wide definition, which includes contact details, includes physical addresses. Just if you can think about any kind of information that you have interacted with in your business operations, I think there will be a very slim chance to actually say that information was not personal information. So in that first instance, it's then identifying that yes, the act does apply. And then the next step is identifying how does it apply. So an initial practical tip there would be for the SMME to understand, after having answered the question, does the act apply? The second question would then be, how does the act apply? And to be able to answer those questions, it's being able to identify the kind of personal information that is being processed in your organization's operations. So when you are doing business on a day-to-day, what kind of personal information does your business process? Are you able to answer that question? In some instances, responsible parties and prospective clients are not able to answer that question. Some organizations are not aware of the kind of personal information that their business operations are processing. Some are not aware whether it is special personal information or even if they are processing personal information of children. And also, some might not even be aware of why they are processing the information, which is very important in terms of fulfilling the conditions of the purpose for processing the information. Some may be processing information without the consent of data subjects. Some may be processing information and not even be applying the, the requisite safety and data security requirements and safeguards that need to be implemented to safeguard that information. So that's a very important analysis, and we recommend that as a starting point. We would recommend that instead of starting with a all-out gap assessment where the all of the operations of the business and the business's processing of personal information is assessed all out, looking at all the different parts of the business and where there are touch points. One, it would be preferable for one to actually start with the either the very high risk instances where personal information is processed, or start with the instances of process that are very vital to the operations of the business. Then being able to identify how the personal information is processed in those instances. So for example, if it is a instance of processing of personal information that is high risk or that is vital for the business to operate, being able to identify what what steps are taken for the processing to happen. Is the information obtained from the data subjects directly? How is it obtained? Are the data subjects providing consent for the personal information to be provided or to be processed? Are the data subjects informed of why the personal information is processed? Are they also aware of what the personal information or where the personal information will be shared and for what purposes? So being able to pinpoint one process of processing of personal information or one activity of processing of personal information within the business and being able to answer a certain set of questions allows us to start a pinpointing process, which will give us a more practical understanding and more practical next steps that we're going to take in our compliance journey. So now, step two talks more about understanding the Act. So, how does the Act apply to my business? So, how does answering that question, how does the Act apply to my business, is a very vital question. It's a very important question to answer in terms of understanding the application of the Act, in terms of understanding, am I processing personal information? Am I processing special personal information? Or am I processing the personal information of children? Because all of those different types of personal information have different compliance requirements within themselves. In some instances, for example, with the processing of personal information of children, that requires the consent of a competent person. A competent person is defined in the Act as someone who is either the parent or the guardian of a child. So these are very important details to consider once you've been able to answer or get through that first part of the analysis of where you are processing the personal information, and then being able to identify how does the act apply to that kind of processing that you have been doing in the first step. And then also very important is just being able to have a good understanding and a good overview of all of the different processing activities that are happening in the organization, the different places where processing is happening in the organization, because you could have personal information being processed by one part of the business and personal information being processed by another part of the business, where there could be overlaps, or there could also be instances where the departments or the people within the business, if there are no departments per se, are also processing the information in silos, where some people are not aware that certain processing is happening in a certain way. And it's very vital that the business operations are aware and know what processing is happening and where it is happening. In the third section, talking about responsibilities, I think in our view here at this point, it's where we can actually start to say, okay, we have been able to identify a very vital processing activity in the business. Maybe now we can actually start looking at some kind of gap assessment that can be implemented to look at the different parts of the business to actually ascertain what other processing activities are happening in what other different parts of the business. So yeah, we would have started with a very specific and pinpointed approach, and then start to have a wider look at the business and look at the business operations as a whole, and then implement that gap assessment. And then further to that, under responsibilities, is then being able to have stakeholders and responsible people within the business who are aware and who are actually the people that are responsible for implementation of the compliance requirements in the business. So in the act, there is a designation of an information officer. So for private bodies and for businesses such as ourselves, SMMEs and entrepreneurs, it's important to note that by default, the person who is the head of the business, the CEO, will have the designation of information officer by default. Then the information officer then has the responsibility and the prerogative to also then appoint deputy information officers, because it would be nearly impossible for the person who is overseeing the operations of the business as a whole to then also be responsible to implement POPIA compliance within the business. So that is when it then comes to the step of being able to identify who in the business can also be appointed as a deputy information officer to assist with the compliance efforts that need to be implemented going forward. And then when the responsible people in the business have been appointed, and they have been identified and appointed, it then allows the next steps to have the conversations that need to be had regarding the impact of the compliance requirements on the business operations and what other actions need to be implemented. Then we can start having further discussions around resources. How many deputy information officers, for example, need to be appointed? That would then be based on the size of the business and the operating requirements of the business, and the complexity and the number of processing activities also that are taking place. So that will then require planning, being able to identify what steps need to be taken in the compliance journey, being able to identify further resources that might, for example, be cybersecurity resources or some technology resources that also need to be implemented in the journey of processing personal information, be it at the outset of the processing or it is for security and safeguarding purposes. And also, this part also allows for further stakeholder engagement to implement training programs and training solutions within the business. For some big organizations, because there are so many processing touch points in the organization, it is very vital that there are training sessions implemented and that there are training discussions that happen throughout the organization, and being able to get all of the different processing touch points within the business aware that they need to comply with the act, and also how they need to comply with the act. In small organizations, those could be less intensive training sessions. They could be discussions that need to be had, uh, something such as taking a day away from the office and being able to have a training or a workshop session regarding the compliance of requirements, regarding actions that need to be taken, regarding the steps that need to be taken to make sure that the compliance journey is ongoing and everything is taken care of from a compliance perspective. So, step five, after all of these things have been done and some of these practical steps have been followed, will mean that there is ongoing compliance support. We, in our view as a firm, the POPIA compliance journey is not a journey that starts and is implemented in a space of a month. It's not a journey where compliance is achieved and then we stop with the compliance efforts. It needs to be considered as an ongoing journey to make sure that there is always adjustments that need to be made in the compliance journey. Because for example, in some instances, your business could start out processing personal information and only personal information. But as your business operations change and your product and service offerings change, you might find that at some stages you are processing special personal information or personal information of children. And as mentioned previously, that will come with its own different levels of security safeguards that need to be implemented. So it's an ongoing journey and requires health checks along the way so that there is ongoing support that is implemented and there are changes that need to be made along the way. So the practical compliance tips are not a one size fits all solution. Your business operations could be processing personal information in different ways to the next SMMEs business operations. So this session and the presentation, the intention of it is to get you a brief overview and introduction of some practical tips you can start implementing. And then if you have not started out on your journey, that is, and then if you need to enhance your journey, to actually give you some tips and pointers. So as I was saying there, the important aspect is being able to identify the the the, the tips and the compliance actions that will be best applicable to your business operations, and to making sure that your business operations are compliant within your resources and in a way that will not disturb your business operations, and in a way that is also affordable and practical, because it does not make sense for an SMME to implement a POPIA compliance program or project that is similar or equivalent to a POPIA compliance project or effort that is implemented by a large company, purely because the processing actions will be different. The amount of personal, the variation of personal information that would be processed would be different. The processing activities would be different. And there are just a lot of different factors that need to be considered and need to be factored in implementing a much more, if I can call it, lean and practical solution that is focused on not just getting compliant and not just implementing all of the compliant requirements, but also making sure that the compliant efforts are done efficiently, they're done practically, and they're also done properly, and that no corners are cut along the way. So this engagement, we would also really appreciate that if there are any questions, which we will answer after the presentation, that they be engaging questions. If you have any items that you want to discuss in the session, we can do that. And also, we are also available for any further discussions after this session, where we can actually start answering questions in a way that applies more specifically to your business operations. So as part of the session, what we will also do is collect contact information, your email addresses, contact numbers, so that we can share further questionnaires to start you on your journey or to enhance your journey further, where we can then be able to pinpoint specific details regarding your processing activities and the different kind of processing activities that are being implemented in your organization's operations, and then being able to go further into the next steps of the service offering we can provide, and being able to give you some indication in terms of the pricing or any other items that you might require, either in the form of policies that need to be drafted for your business, or where, for example, you have a website as part of your business, the kind of privacy policies and notices that need to be displayed on your website, for example. And then if the processing of information, for example, is happening with data subjects in person, the kind of forms that need to be signed off, and the kind of discussions that need to be held with the data subjects, and varying different kind of efforts that can be implemented in your operations. Also, being able to establish a framework, and then also being able to implement any other compliance requirement that your specific business operations need to have implemented to make sure that your business operations are compliant. So that is it from us. I see we are coming to the 52-minute mark. So I think we can leave the rest of the session to be able to answer any questions that the attendees might have. Thank you.
Thank you. Thank you, Masala, for that very insightful presentation.
Thank
In the absence of questions, so we will rerun this presentation across the board. Unfortunately, as I hit go live, something went wrong between the platform we use and Facebook. So I will
Yes,
have
yes,
the Facebook as a repeat or a rerun.
yes.
But to those who have joined us, we do encourage you to, whether you have a question now, you can do so in the comments. If later I've shared the details on the screen for you to get hold of Mr. Ratshitanga. Maybe a question just before we part ways from me. You so when you speak of a gap analysis, from your experience, at which point of the business would you suggest that one do some kind of an analysis? And I'll tell you why I'm asking this question, but not related to the POPI Act, right? From experience, it's usually costly, way too costly when I have to deal with something when there's a fire already, and there was no foundation or some kind of activity, to mitigate against that risk. So at which stage would you say one should consider doing some kind of an analysis, and what would you say the frequency is during the life of the business?
Yes. So yeah, that's a very great question. So I think if we're talking about a gap analysis generally, and we are talking about corporate governance generally speaking, I would recommend that at the outset of the business operations, being aware of what compliance touch points your business will need to comply with is very important. So it being, for example, operating in a specific industry, you could find that your business operates in a regulated industry. So, as a starting point, that would be some of the governance items you need to address from the outset. For example, in our own operations as a law firm, from the outset, we are required to comply with certain requirements that are imposed by the Legal Practitioners Act. We are regulated by the Legal Practice Council. they hold sessions and seminars and explain the different compliance requirements from a practical perspective. So I would say, depending on the industry you're operating in, that is a good starting point if it is a regulated industry. If the industry is not regulated, then one would need to consider the kind of legislation. South Africa is a very complex legislative framework in terms of business operations. One needs to consider, for example, the Companies Act. How does the Companies Act apply to your business operations? For example, if you are operating as a sole proprietor, you won't necessarily have to have any registrations. But then, if you are operating as a proprietary limited or a personal liability company or an NGO or other operation, then you actually need to have registrations done with the CIPC. So those are the kind of things that need to be implemented as a starting point, and making sure that there's legislative compliance with the different legislation, and then also with the different regulatory requirements. So some are straight and obviously implemented, some are not so obvious. And once you have been able to identify which kind of items apply to your business from a regulatory and a legislative perspective, of course, if the assistance is required with the assistance of a legal professional, the next step then is being able to identify how those legislative and regulatory compliance requirements impact your business. And that can be done either at the outset of the business. It can also be done when the business is already operational, as an effort to avoid any fires, as you mentioned. And once that analysis has been implemented, looking at all the different parts of the business and all of the different compliance requirements, it would be prudent to do it very practically, engage as many stakeholders within the business operations. And also, very important is that the compliance and the gap analysis process should be an ongoing process to be able to assess what kind of changes have happened in the business from the initial gap assessment to the next gap assessment, because business operations in some instances change. In practically, in actual experience dealing with clients, having dealt with, for example, clients that would have been operating in an industry where they are regulated by certain um, license requiring legislation, to finding that in some instances they no longer need to have a certain type of license, or they need to change the kind of license because now they have, through their business development efforts and innovation efforts, have identified a different service or a product offering that they want to look into. And then that product offering or that service has its own different kind of regulatory and legislative framework that needs to be complied with. So gap assessments and those kind of compliance assessments need to be ongoing to actually look at, they cannot be stationary, because business operations and our experience are never stationary. Business operations, especially in 2023, in the environment we are working in, with the different developments technologically, AI is now involved. there is cryptocurrencies, there are all these different things. With all of these new different technologies and innovations that come into the business environment, and also uh, businesses constantly innovating and changing their product offering, it's very important that the gap analysis is an ongoing project. What I would recommend that if a new product offering is being implemented, at the outset of it being implemented, that an analysis needs to be made on how it will impact the business. If there are no constant changes in the product offerings or the operations, then one would recommend that it is a process that is implemented at least twice a year.
Okay, no, thank you for that. We've got one question which I think will make it our last question from Tabo Makete. I hope I pronounced your surname correctly. He actually made two comments. So the first one, I will just read. It says, "Good day. This has been a great eye-opening presentation. Are the slides available?" And the answer to that is yes. If you
Yes,
did
yes.
register on the link that we shared, but I see you did. So we will distribute to those that did register. Mr. Ratshitanga, there's a question that I've put on the screen. So, how would the POPI Act affect a community health facility which handle confidential HIV and other health statuses, particularly where the person has to be linked for further health interventions? Over to you.
Yeah, so that question, that is also a very great question, because that question specifically is talking about special personal information. So the health status of a person is considered special personal information under the Act. Special personal information in itself has a very stringent processing set of compliance requirements that are over and above the processing of personal information. So when it now comes to processing of special personal information, it's very vital that the conditions of processing are complied with, and they are complied with very stringently. Things such as consent, things such as processing limitation, and conversations that need to be had with the data subject in this regard require a higher and much more stringent level of care and implementation, and the security needs to be extremely and highly safeguarded. So, to answer the question, without going too much into the further details of the information itself, it's very important to just be aware that the information is special personal information, and it has a very high and stringent requirement when it comes to complying with the Act. So, in terms of consent, the consent needs to be very informed. In terms of processing limitations, those need to be enforced very stringently. And also the effect on the different parties involved in the processing itself. It also needs to be communicated further to the different people involved in the processing of that personal information, that it is special personal information. And then further to that, what we can help within such a situation where um, Tabo Makete has raised this kind of question, we are available to actually have one-on-one, a obligation-free consultation and a further discussion to be able to get more details and more information around the operations that are actually currently underway and the kind of processing that is happening in that organization. So
Great.
please shoot us an email or a
Yeah,
WhatsApp and we can get in touch.
great stuff. Thank you very much, Council. Thank you for affording us your time, sharing your insights. I have shared your details across the screen.
Yes,
We
yes,
will do reruns, and I think between you and I, we need to get back on this. There's definitely a lot more to be unpacked.
definitely.
um,
Yes,
that
yes,
could not be contained within 1 hour. So I
yes,
think there's a
yes.
lot more room to
Mm,
maneuver and be able to benefit our listeners or our audience. In mind, for instance, it's we were talking within the South African context. How do we deal with cross-border data transfer?
mm, mm.
Uh,
Yes,
now we are fetching about GDPR and all of those things,
exactly, exactly.
which is another discussion in itself that I would like for us to explore.
Yes, yes.
Again, thank you for your time, and I
Mm.
will distribute the presentation. And thanks to our audience. Enjoy your day.
Great. Thank you very
Thanks.
much. It was a pleasure.
Thank you.
Thank
Thanks.
you.
Bye.
Bye.
Bye.